Welcome to the first English language session of the Tilakey and Gibbons 2021 Employment Law Forum webinar series. It is now my absolute privilege to kick off the webinar and introduce you to today's speakers. Today, covering the topic of transfer of employment under Thai labour law, we have Pimwamon Wickramanira and Dusita Kani Jo. Pimwamon, more usually known as Kunjun, is head of Tilakey and Gibbons non-contentious employment practice and is a partner in the firm's commercial group. Kunjun advises many of the world's largest companies on the full range of labour and employment matters related to their activities in Thailand, covering labour protection, employment agreements, termination of employment, labour unions, transfers, due diligence in M&A, work rules and regulations, social security, workman's comp. The list really does go on and on. She is one of Thailand's most sought after authorities on labour and employment matters, and she's regularly featured in legal publications from around the world on labour and employment law, including those produced by the World Bank, the American Bar Association, Lex Mundi, Multi-Law, and the Centre for International Legal Studies. She's perhaps no surprise, she's also regularly asked to contribute to business-focused articles too, people like the Bangkok Post and Oxford Business Group. Also a frequent speaker on employment law from organisations as diverse as the United Nations and the World Bank to Joint Foreign Chambers of Commerce here in Thailand, and a whole host of European Thai Chambers of Commerce, as well as the Bangkok Ship Owners Association and various employment law firms. Perhaps no surprise to anyone then that she is recognised as one of the best in the country by directories including Chambers Asia Pacific and joining Kunjun today is Dusita Kani Jo, a consultant in our corporate and commercial department here at Tilakey and Gibbons Bangkok. Dusita's practice focuses on helping international and local clients with their labour and employment matters in Thailand. And again, a similarly thorough list to Kunjun: employment agreements, terminations, work rules and regulations, and employee benefits. Dusita also handles a broader range of commercial work that often impacts the employment law context. That includes things like share disclosures and restructurings, corporate formation, regulatory advice for securities and derivatives, SEC matters, and antitrust and competition matters. Dusita holds an undergraduate law degree from the University of Manchester and an LLM from the LSE, both in the United Kingdom, and she's fluent in both English and Thai, as well as conversant in Punjabi and Hindi. I understand that we'll do English today, just for my sake, I think. Okay, I'm sure you'll agree there is nobody better to take us through this fascinating topic today. And on that note, I will turn it over to Kunjun.
Oh, thank you so much, Khun Sep, for introducing me and Dusita. Good afternoon, everyone, and Sawadee Kha. My name is Pimwamon Wickramanira, or you can call me June. Today, I'm here with our young, bright, and one of our rising star, Dusita Kani Jo, who is one of the members of our employment team at our Bangkok office.
Good afternoon, everyone, and Sawadee Kha.
In today's presentations, we would like to discuss transfer of employment under Thai labor laws. This has been a particularly hot topic recently. Is that right, Dusita?
Yes, indeed, Kunjun, a very, very hot topic indeed.
You know, Dusita and I and our employment team have been very busy with several employment transfer projects. And now let's start with the first point that many people may be wondering about. Dusita, what constitutes transfer of employment?
For the definition of transfer of employment, we may look at Section 13 of the Labor Protection Act. Section 13 states that the transfer of employment is where there is a change of employer, including where an employer changes as a result of transfer of functions or employees from one juristic person to another, or where there is a registered merger between the employer and another juristic person, which results in a new entity. Kunjun, could you please provide us with some examples of circumstances that would constitute a transfer of employment?
Of course, one example is where it is an acquisition of a company by asset purchase. In this case, because there is a transfer of assets from the existing companies to the new company, which also includes the transfer of employees. So the transfer of employees from the existing company to work for the new company shall constitute a transfer of employment.
How about where there is a merger between company A and company B to company C? In such case, if employees of company A and company B have to become employees of company C, will this constitute a transfer of employment?
Yes, it will. In this situation, the employer, who is the juristic entity, has merged with another juristic entity, resulting in the employees becoming employees of a new employer. This is a transfer of employment because there is a transfer of the rights and obligations of the employers from company A to company B to the third party, which is company C.
How about when employees are transferred to another company that is within the same group as the existing employer? Is this a transfer of employment?
This is an interesting issue. There is a Supreme Court decision on this issue. It is the Supreme Court decision number 3002/2561. The facts of this case are as follows. The existing employer transferred the employees to work at a different company, which is a company within the group of the existing employer. Both companies have the same directors. The Supreme Court ruled that although the directors of the two companies are the same, the companies are considered to be separate legal entities. Accordingly, this shall constitute a transfer of employment, and the employee's consent must be obtained. Where an employee refuses to give consent to the transfer, the existing employer would not be able to transfer the employees to the company within the same group. Now, let me ask you as well, Dusita, in the case of the acquisition by share purchase, for example, company A buy the shares in company B. In this case, is there a transfer of employment?
No, this will not constitute a transfer of employment because employees of company B will remain as employees of company B. In this case, there is no change of employer. The only change is to the shareholders in company B, and the employment relationship between company B and its employees will remain intact.
A lot of questions have asked, what if there is a change in the name of company B to a new name, for example, to company C? Will this constitute a transfer of employment?
The answer to this is also no. Changing the company's name to company C does not constitute a transfer of employment.
Wow, Dusita, you are good. I'm wondering who is your mentor.
Right here, Kunjun.
Oh, okay, thank you. I would like to add that the Supreme Court decision number 1000/21005/2558 deals with these issues. The Supreme Court ruled that although the company may have changed its name and its shareholders, there is no change to the legal entity. In such case, there is no transfer of employers' rights and obligations to third parties. As a result, there is no transfer of employment.
Now that we're all aware of the circumstances which will fall within the scope of transfer of employment, let's discuss the steps in an employment transfer. Kunjun, I understand that when there is a transfer of employment, the existing employer must obtain the employee's consent. Is that correct?
Yes, this is correct. The issue of consent is dealt with in two legal provisions. The first is Section 577 of the Thai Civil and Commercial Code, which states that the employer may transfer his right to a third person with the consent of the employee. The second legal provision is Section 13 of the Labor Protection Act, which states that the employee's consent to be transferred to a new employer is required.
Well, the obligation to obtain prior consent of the employee was already provided for in Section 577 of the Civil and Commercial Code. Prior to the recent amendment of the Labor Protection Act, the Labor Protection Act was actually silent on the issue of consent. So to remove previous ambiguity and afford greater protection to employees, the amendment to Section 13 now makes it very clear that in the case of transfer of employment, the employer must obtain the consent from the employees who will be transferred. So Kunjun, does the law state how an employee's consent must be obtained? For example, does consent have to be in a written form?
Well, while there is no legal requirement on the form of consent per se, both explicit and implied consents are acceptable. However, Dushita, what do you think is the best way to obtain an employee's consent?
We would generally recommend that employers obtain the written and explicit consent of the employees to be transferred. This would help minimize any futures in the future, such as any employees subsequently complaining that they actually did not consent to the transfer.
That is correct. In any case, the courts have ruled that implied consent is acceptable. The Supreme Court decision number 7945/2554 discusses this issue. In this case, the existing employer transferred the employee to the new employer. The employees did not oppose the transfer and continue working for the new employer for 2 years and 9 months. The Supreme Court ruled that the employees had agreed to the transfer of employment to the new employer by implied consent.
How about if the period of time which the employee went to work for the new employer is less than that, for example, 1 year or 1 month? In such case, will that constitute implied consent?
Or for this one, you have to look at the Supreme Court decision number 1371/2557. In this case, before bringing the claim to court, the employee went to work for a company within the company group for 5 days without making any refusal or objection to the transfer. The Supreme Court ruled that the fact that the employees went to work for the new employers for 5 days without making any refusal or objection to the order made by the existing employers, this was regarded as the employees has consented to the transfer of his employment to the new employer.
This is also similar to Supreme Court decision number 9018/2550. In this case, the employee undertook work at the work table of the new company for 15 days, during which the employee did not oppose or object to the transfer. Interestingly, the employee's place of work with the new employer was within the same office, and the work table of the new company was actually only a few meters apart from the employee's previous work table. In this case, the court found that the employee had agreed to go work at the new table for 15 days without objecting. Therefore, the employee had consented to the transfer of employment to the new employer. From these cases, we can see that employees' consent may actually be interpreted by their action.
The Supreme Court decision that we have discussed are evidence to the fact that implied consent is indeed acceptable to the Thai courts. However, the best option is still for the employers to obtain the employees' explicit written consent.
How about in the case that the employment agreement states that the employer has the right to transfer the employee at the employer's discretion? In such case, does this mean that the employee had already implicitly consented to the transfer?
Where the employment agreement between the employer and the employee stated that the employer has the right to transfer the employee's positions or work duties to a company within the group. This means that the employment agreement only gives right to the employers to transfer the employees' positions or work duty to a company within the group. However, this does not mean that the employees has provided prior implicit consent. For this, we can look to the Court of Appeal for Specialized Case Decision number 326/2563. In this case, the employer transferred 4 employees to work for a company within the group. The employer claimed that the employment agreement between the employers and the employees stated that the employers has the right to transfer the employees' positions or work duties to a company within the group. The court ruled that a transfer of employment to the company within the group was indeed a transfer of employment to a third party, which required the employee's consent to be obtained. The fact that the employment agreement stated that the employer has the right to transfer the employee's position or work duties to a company within the group means that the employment agreement only gives right to the employer to transfer the employee's positions or work duties to a company within the group. Again, this does not mean that the employee has provided prior implicit consent. Accordingly, the court held that the transfer of employment without obtaining the employee's consent was not consistent with the law. The court also elaborated that where the employer transferred the employees to work for the company within the group without the employee's prior consent and the employment with the employer was ended, shall constitute a termination of employment without cause. Therefore, the employers must make payment in lieu of advance notice, severance pay, and damages for unfair termination to the employees.
Now let's move on to discuss the correct and proper way in which employees may be transferred to a new employer.
As a first step, it is important to review the key documents of the existing employers and the new employers, such as the employment agreements of the employees to be transferred. This is because the employment agreement will contain provisions regarding the employee's condition of employment, such as wages, benefit, and welfare. In addition, we have to review the work rules. The work rules are also considered to be an important employment document because they contain details of the employment conditions. For example, working day, working hour, annual holiday, leave days, overtime, termination of employment, severance pay, and etc.
It is also important to review all other HR rules and policies to see whether they contain any provisions and/or requirements for the transfer of employment. For example, if there is a collective bargaining agreement with the employee or a labor union, there may be some points that we need to verify as to whether there are any special rules or obligations in connection with the transfer of employment. The second step would be to inform the employees that are to be transferred of this impending transfer of employment and also the circumstances by which the transfer will arise. Employers should ensure that employees are duly informed about key details related to the transfer, such as who is the new employer, what is the effective date of transfer, the benefits and welfare that the employees will be entitled to. For example, whether they will be entitled to the same benefits and welfare, better benefits and welfare, or worse benefits and welfare. This would ensure that the employees have all the relevant information when considering whether or not they should consent to the transfer.
I would like to highlight on these points. Section 13 of the Labor Protection Act states that the new employer will assume all rights and responsibilities owed to the transfer employees from the previous employer. Therefore, the new employer must accept all rights and responsibilities in regard to the transfer employees. If the new employer would like to change any of the benefits or welfare regarding the employee's condition of employment, the new employer must inform the employees accordingly and may need to obtain consent to change any of the benefit or welfare if such change is less favorable to the employees. There are various ways in which the employers may inform the employees, such as by calling a town hall meeting with all the employees to be transferred, or if it's not possible to have a town hall meeting, or if the employer does not want this kind of meeting with all the employees, the employer may have a separate meeting with employees in each department. The information that must be conveyed to the employees are: who is the new employer? When is the effective date of the transfer of employment? What are the benefits and welfare that the employees will be entitled to after the transfer to the new employers? The employee's year of service within the existing employer will be included and counted continuously as part of the employee's year of service with the new employer. Whether the employee's position or role will remain the same, the employee's workplace, whether it will remain the same or whether the employee will move to a new place. After informing the employees, the employee must send a letter of consent to the transfer of employment to the employees. It is important that the employer must give the employee enough time to decide whether they would want to consent to the transfer or not.
So, Kunjun, what information should be stated in this letter of consent?
Well, the letter of consent should clearly state the details of the information that have been verbally provided to the employees during the meeting.
How about if the new employer may not provide the employees with the same benefit or welfare that the existing employer provided? What should be done in this case?
As a starting point, it is important to note that under Thai law, an employer cannot unilaterally change the employee's condition of employment unless such change is more favorable to the employees or the employees expressly agrees and consents to such change. The new employer should bear in mind that it cannot reduce the employee's compensation or benefit without the employee's consent. In general, as compensation and benefit may differ between each company, this may raise the question of whether certain discrepancy in benefits would constitute a reduction or improvement. The situation of the new employers not being able to provide the same benefits or welfare as the existing employers actually happen quite often because the new employer may not provide the same benefits and welfare that the existing employer provided in the case to the employees. This issue normally happens in the case that the new employer is not within the same group as the existing employers, such as in the case of an asset acquisitions. In this case, I would advise that the new employer looks to all the benefit and welfare of the existing employers provided to its employees and compare the benefit and welfare and determine whether the new employer would be able to adjust the benefit and welfare to match that of the existing employer provided to its employees. Dushita, do you have any example on this?
Yes, Kunjun. So for example, the new employer may not provide the same number of annual leave entitlements as the existing employer. Or another example is that the existing employer may arrange for the transportation buses to various places for its employees, such as to BTS stations or to MRT stations. But the new employer does not have a policy on providing transportation for the employees. So in this case, the new employee is unable to provide the employees with the same benefits and welfare. We would recommend that the new employer enter into new employment agreement with the employees who consented to the transfer. This new employment agreement must clearly state all the conditions of employment. So maybe the new employment agreement could be provided to the employees along with a letter of consent so that the employees may consider the entire circumstances of the transfer prior to providing their consent.
I would like to add that actually the law does not state that employment agreement must be made in writing. An employment agreement may be made verbally. However, it is recommended that a written employment agreement which clearly states the condition of employment be provided. This will act as evidence in the case that there is a dispute between the employer and the employees regarding the condition of employment.
Additionally, there will be no break in the employee's years of service. In other words, the new employer must continue counting the employee's years of service with the existing employer as well. This means that the employee's length of service will continue to count towards any service-related benefits to which the employee may be entitled to. One example is annual leave. Certain companies have the policy that an employee's annual leave entitlement will be based on their years of service. For example, after working 1 year, they may be entitled to 6 days of annual leave. After working for 5 years, the employee may be entitled to 10 days of annual leave. The years of service is also relevant for employees when calculating their severance pay entitlement in the case of termination without cause.
The letter of consent should also state that the employee agrees to comply with the new employer's policy and work rules. In addition, the letter of consent should contain a provision stating that the existing employer may transfer the employee's information and data to the new employer.
The reason that such provisions on transfer of data should be inserted in the letter of consent is because Thailand's Personal Data Protection Act will come into full effect on 1st June 2022.
Yes, this is correct. This consent letter should be made in the form of a tripartite agreement between the employee, the existing employers, and the new employers, and all parties must sign this letter. This would also allow the employees to be confident in the fact that the new employer has also agreed to accept the transfer of their employment. With respect to the language of the letter of consent and the employment agreement, the law does not state that such documents must be made in Thai. However, if an employee is Thai and does not understand English well enough to fully comprehend the term of the document in English, then it would be strongly advisable to have the documents be made in Thai as well. This would be helpful in preventing an employee from raising the issue that he or she misunderstood the term and condition of the document in English.
The next step involves informing the Social Security Office. Both the existing and the new employer must prepare documents to submit to the Social Security Office. The new employer must prepare a notification of new employees for the Social Security Office, whereas the existing employer must prepare a notification of cessation of the employee's employment.
To help you all visualize the steps and timeline involved in the transfer of employment, you may refer to this timeline as an example. As you can see, the process of reviewing the relevant employment documents should take place at least 90 days prior to the transfer. If there are more documents to review, the 90 days can be extended. After that, approximately 60 days before the transfer, the existing employer should inform the employees regarding the transfer, as well as send the letter of consent and or the new employment agreement to the employees if there are changes in terms and conditions of employment to be provided by the new employers. The letter of consent to the transfer should be returned to the existing employer at least 50 days before the transfer.
Closer to the transfer date, about 10 days prior to the transfer, the existing and the new employer should begin preparing the notification to the Social Security Office. After the effective transfer date, the new employer must submit a notification of new employees to the Social Security Office within 30 days after the transfer. The existing employer will then submit a cessation of employees' employment with the Social Security Office within the 15th day of the month after the transfer. After the transfer of employment, the obligations of the existing employer, who is the transferor, and the obligations of the new employer, who is the transferee, will differ.
That is correct. So, Dusita, do you know what are the obligations of the respective parties are?
Yes, Kunjun. After the transfer of employment has taken place, or in other words, after the effective date of transfer, if the employee has consented to the transfer, the existing employer will have no post-transfer obligations to the employees, except for any liabilities that may have accrued prior to the transfer. After the transfer, the new employer will assume all rights and responsibilities owed to the transfer employees by the existing employer. So, Kunjun, how about if an employee does not consent to the transfer? What will happen then?
Or this happens in the case that an employee refuses to give consent to the transfer, the employee will continue being employed by the existing employer. However, the existing employer must now consider whether or not it would like to continue employing such employees or to terminate these employees. For example, in some instances, after the sale of business operation to the new employer, the existing employer may want to cease business operation and or no longer require the services of the employees. Then the existing employer would have to bring the employment relationship to an end. Therefore, the existing employer would have to terminate the employees who did not consent to the transfer. If the existing employer was to terminate the employees, the existing employer would have some obligations to the employees to be terminated. Dusita, I would like to ask you to share with us with this obligation, please.
Yes, of course. As you can see from the slides, these are the obligations of the employer. Number one is to provide advance notice of termination or make payment in lieu of notice. Number two is to pay statutory severance pay based on the employee's years of service and at the last wage rate. Number three is to pay wages, overtime pay, holiday pay, and holiday overtime pay all the way through the last day of employment. Number four is to make payment in lieu of the employee's unused annual leave days, if there are any. Number five is to return the security deposit, if there is any. Number six is to make all other payments that may be due under the employment agreement and any other applicable terms of employment. And finally, it is to issue a certificate of employment.
You know, sometimes client asks that what you say in the certificate of employment, you know, you can make it very simple. Just say that the employee's name and when was the commencement date and when was the end date. And you can say that you may include the position of the employees. You don't need to say that how great the employee is. That is not necessary.
I note that clients often ask us about the advance notice of termination. Kunjun, can you please elaborate on how the advance of notice of termination must be given?
Broadly speaking, under Thai law, employment agreement can be categorized as either fixed-term employment agreement or open-ended employment agreement. Under Thai law, a fixed-term employment agreement is an agreement which states the commencement and the end dates. This type of employment agreement will expire at the end of the agreed period without the need to give advance notice of termination. There is no minimum or maximum period of employment, as the employee are free to agree on the length of the employment period as they deem appropriate. However, it is important to note that in order to be effective as a fixed-term agreement, the agreement must not contain any provisions that purport to allow an employer or an employee to terminate the agreement prior to the end of the agreed period or to extend the term of the agreement. The Supreme Court has ruled that an employment agreement which contains a provision to terminate the agreement prior to the expiry date is not a fixed-term employment agreement. As such, If the employer would like to terminate an employee without cause, the employer is required to give advance notice of termination, at least one pay period notice to the employee, or make payment in lieu thereof. You may notice on the slide as seen in green font that I will use the term open-ended employment agreement here. Dusita, can you please explain what is an open-ended employment agreement?
Sure. An open-ended employment agreement is an agreement that provides for employment without a definite end date. The agreement will only state the commencement date. When the employment agreement is an open-ended agreement, an employer or an employee may terminate the agreement by giving advance notice on or before any date of wage payment. For the termination to take effect the following date of wage payment. This is known as one pay period notice. In other words, there must be one complete payment cycle between the date that the employee is notified of his or her termination and the date that the termination takes effect. If a longer notice period was agreed upon in the employment agreement or in the employer's work rules, then the employer is obligated to comply with such agreed period. But however, the law does not require more than 3 months of notice to be given.
I would like to add that the notice of termination is often misunderstood. Employers who pay their employees monthly often think that they must simply give 30 days notice or 1 month notice. However, as explained by Dusita, the required period of notice under Thai law is a one-page period notice, which can be longer than 30 days, depending on the employee's payday and the date that the notice of termination is actually given. Thus, when an employer wishes to terminate an employee without cause, the employer must take the date of payment of wages into consideration. For example, if an employee receives wages once a month on the 25th of each month, and the employer wishes to terminate the employees effective on the 25th of March or at the end of March, the employer must provide a notice of termination to the employees on or before the 25th of February. If the employer gives a notice of termination after the 25th of February, for example, on the 26th of February, the effective date of the termination would be pushed later to at least 25th of April.
In any event, the employer may choose to deliver a notice of termination with immediate effect, provided that payment in lieu of notice is simultaneously made to the employees. Therefore, employers should carefully time and give proper advance notice of termination to the employee. Otherwise, the employer may end up paying higher wages in lieu of notice.
Lushita, how about when the employer terminates an employee during probationary period? Thus, the employer is obligated to give advance notice of termination as well?
Yes. Probationary employees are entitled to the same notice of termination to which other employees are entitled to. Employers should make sure that if they want to terminate employees during probationary period, the employers give the required notice to the employees or make payment in lieu thereof.
Now let's move to talk about severance pay. Severance pay is calculated based on the employee's year of service. As you can see, severance pay ranges from 30 days to 400 days, depending on the length of the employee's service with the company. For example, if the employee completed 120 days, but less than 1 year, the employee will get 30 days severance. The maximum severance pay here is 400 days. For the employee who worked for 20 years or more.
So Kunjun, you've been working with Tilaki for much more than 20 years now.
Oh no.
So when you retire, you will receive 400 days wages, and you'll be even richer than now.
Wow. All right. All right. I will take you out for dinner to celebrate when I receive my retirement benefits. Actually, as mentioned by Dusita, retirement is regarded as termination without cause, and the retiring employee will be entitled to severance pay.
So what constitutes wages? Is it merely the salary that an employee receives every month?
As a general rule, any money and or benefits given by periodic payments for which the employees need not submit receipts for reimbursement would constitute part of wages. For example, if an employer agreed to provide its employees with certain benefits in a form of money in a fixed amount and pay on a regular basis, such as a position allowance of 10,000 baht a month, housing allowance of 50,000 baht a month, or transportation allowance of 10,000 baht a month, without requiring the employees to provide receipts or any other supporting documents or evidence to reimburse such payments. The court will likely determine that such monthly allowances are part of wages for the purposes of calculating severance. Dusita, what about the benefits that are not in form of money? For example, a car with a driver or health insurance provided by the company?
We have to look back at the definition of wages. As you can see from our slide, wages is defined as money paid to the employees. So if the employer provides its employees with other benefits which are not paid in monetary form, this will not be regarded as wages. Therefore, it is important that when the employer negotiates the employment agreement with the employer must clearly specify that any other employment benefits provided to the employees are welfare and benefits provided to the employee, and that this will not be regarded as part of the employee's wages or will not be included in calculating any paid leave, paid holiday, severance pay, or any other contribution. So Kunjun, it is almost December. I'm sure we are all thinking about a bonus right now. What do you think? Is bonus wages?
Of course, my dear, we are all thinking about bonus and hope that there will be bonus for us, finger crossed. Okay. In any case, to answer your question, bonus is not part of wages. There are several Supreme Court judgments rule that bonus is not part of wages.
We will now move on to the frequently asked question portion of our presentation.
Okay, so may I ask you for the first question, whether the existing employer can force the employees to provide consent?
The answer is no. This is because the employees are entitled to decide based on their own discretion whether or not they would like to consent to the transfer. The existing employer cannot penalize any employee for refusing to be transferred. Now, I would like to ask you a question. What can the employer do to encourage an employee to provide consent?
The existing employer may consider offering incentives to the employees for agreeing to a transfer. The incentive could take many forms, such as a one-time bonus payment or a special payment. The existing employer may discuss with the new employers to improve post-transfer conditions of employment. It is often the case that the new employer would like the key employees who are central to the business operation to be transferred so that the business will run smoothly and efficiently. Therefore, it would be important that the incentive offered to these key employees are good enough to be able to convince them to consent to the transfer of employment.
May I also ask that after the employee consents to the transfer, can the new employer reduce the employee's remuneration or reduce their employment benefits?
After the transfer, the new employer will be the employers of the transfer employees. If the new employer would like to reduce remunerations or reduce employment benefit, the new employer must obtain consent from the employee for such reductions. I would like to restate that under Thai law, an employer cannot unilaterally change the employee's condition of employment unless such change is more favorable to the employees or the employees expressly agrees and consent to such change. As a general matters, conditions of employment include working condition, working days, working hours, wages, roles and responsibilities, work location, employment benefit and welfare, termination of employment, and other benefits of the employees concerning employment or work. Therefore, almost any change to the condition of employment require the consent of the affected employees. The exception would be where the change to the conditions of employment is more beneficial to the employees. For example, an increase of wages, promotion, which is more beneficial to the employees, and therefore such increment of wages or promotion would not require consent from the affected employees. When it is not clear whether changes would be more beneficial to the employees, then employee consent must be obtained.
Thank you so much, Kunjun. That is very, very useful for all of us to know.
Now we would like to move on to the question and answer part.
Thank you. Oh, excuse me, sorry. Before I get lost in a tunnel there. Thank you very much both for that really, really clear and informative presentation. Just before we do move on to the Q&A, I've had one very interesting request come in, which with your permission, I'd like to put ahead of the Q&A. It's really good. We've had someone arrive about halfway through who's asked if you could give a 2-minute summary of the key points, just to sort of wrap up and give that overview. Would that be okay with you both? Just a 2 minutes?
Yeah, okay. We will try for 2 minutes, you know, with the 45-minute presentation. Okay. Firstly, we will need to consider whether the transaction you are dealing with is the asset purchase or share purchase. If it is an asset purchase, then it will involve transfer of employment. However, if it's a share purchase, there is no transfer of employment. When it is a transfer of employment, it is important that you need to obtain consent from the employees to agree to transfer their employment to the new employers. It is also advisable that the left consent can be made in the form of tripartite agreements signed by 3 parties, the employees, the exiting employers, and the new employers. And if the new employers would like to change any terms and conditions of employment, it is advisable that the new employer should enter into a new employment agreement with the transfer employee, which clearly states the terms and conditions of the employment after the transfer. In the case that if the employee refuses to give consent to the transfer, the exiting employer will have 2 options. First option is to continue employing the employees. The second option, if the exiting employer do not want to continue employing the employees because maybe they close down the business operation, if this is the case, the exiting employer will have to terminate the employees, and thus the exiting employer will be obligated to give advance notice of termination or make payment in lieu of notice, give severance pay, and give any other amount due after the termination. Dusita, do you have anything to add?
I think it would just be important to remind everyone that while implicit consent or implied consent has been accepted by the court, we would recommend obtaining the explicit and written consent just to avoid any confusion or any complaints in the future.
Okay, very good.
Thank you very much. That's really clear and really, really good advice. I appreciate it. Okay, I'll move on to a few of the questions we've received from our attendees. First up, can employees give consent by email, or does it need to be in writing?
By email is acceptable. As we've reiterated, the most important part is to have evidence to the consent. So email is a form of consent that you can later bring up as evidence. So that would be acceptable.
So, thank you very much. We have another query here related to consent. What happens if an employee who has already given their consent then changes their mind? Can they withdraw that consent?
Wow, this is a very interesting question. Okay, I would say that, you know, as a general matter, when you give a consent, you already agree to that. If you would like to withdraw, if the employees withdraw a consent, you will need to get agreement from the existing employers and also the new employer to agree for you to withdraw the consent. To my understanding, there is no direct Supreme Court on the withdrawal of consent. And I remember that if you use the guideline of the resignation of the employees, I understand that there is a Supreme Court judgment rule that when the employees already submit his or her resignation to the employers, and later on, his employee changed their mind, would like to withdraw his or her resignation. I understand that the court ruled that the employees can withdraw the resignation only if the employers agree to the withdrawal.
Okay, no, that's helpful. Thank you, and a good parallel to a similar situation when there's no court judgment. Thank you. That's really good. Okay, one more here. What if a new employer doesn't want to acknowledge the employment period that's been accrued under the previous employer?
Okay, this is sometimes happened as well because, you know, because the year of service, right, is when it's accrued, is meaning that the new employers, if they terminate employees or the employee retire, the severance pay will be huge. So sometimes it's happened that the new employer doesn't want to have the continuous employment year of the employees. So what you could do, one option is that for the existing employer to end the employment relationship with the employees. So in this case, the existing employer may have to pay severance to the employees to end the year of service, and then the new employer can hire the employee from fresh start.
Excellent. No, that's good to know. Thank you. That's very helpful. I think we just have time for one more short question related to what constitutes a change of control. Will a change of control via share acquisition constitute a transfer of good?
Okay, wow. So we discussed about this earlier, about the share purchase. I think Lucia was the one who talked about this.
Yes.
Would you like to take this question?
So a change in shareholders will not constitute a transfer of employment. However, an acquisition by an asset purchase will constitute a transfer of employment.
Yes, if you look back to our presentation, you will find the Supreme Court judgment that we discussed on this issue.
Oh, that's great. Thank you very much. Extremely helpful and very clear. Okay, well, with that, I think today's session is drawing to a close. So thank you again to Kunjun, to Kundusita. That was a really, really great presentation. If you do have any follow-up queries, both of our speakers' emails are on screen now.